appeal in the matter of the King on the applications of Elliott Associates L.P. and another, and London Metal Exchange and another.
Yes, Mr. Chancellor, sorry, will you give me a moment? I don't want this here, so I can't write. Okay, that's fine. Thanks, maybe put that. Right, yes.
So, my lords, I appear on behalf of the appellants with Mr. Jason Pobjoy, Mr. Jonathan Crowe, KC, Mr. James McLellan, KC, Ms. Rebecca Loveridge, and Mr. Alistair Richardson appear on behalf of the respondents. There are a couple of items of housekeeping I wanted to mention. Just the timetable, subject to the court's convenience. We've agreed between us to split the time equally, finishing, of course, by lunchtime on Sunday.
Yes, we saw that. There's just one thing I want to mention in that regard. I have to attend a meeting in the building at 4 tomorrow, which means you will lose a quarter of an hour, 20 minutes, or whatever otherwise we would have had. If necessary, we can sit a bit early on day 3, Thursday, or sit a bit late. But we can make the time up. But I will be leaving at 3:55 on the dot.
Very grateful for that indication.
And when I say I mean we. You won't be left with the other two.
Yes, I assumed as much. Confidentiality, just to mention, you may have seen that there's a confidentiality ring order that was made in the Divisional Court, extended by order of Lord Justice Lewis in March this year to cover these proceedings, which explains why bits and pieces in your bundles are sort of transparently redacted. But we both think that there won't be any need to reveal any confidential information in open court, so that should not cause any trouble. Well, so much for housekeeping. This is, as you know, our appeal against the Divisional Court's dismissal of our challenge to the LME's decision on the 8th of March 2022 to cancel trades to a value of over $12 billion, depriving the appellants alone of gross proceeds in the amount of about $728 million without any compensation. It was a wholly unprecedented decision, and the Divisional Court rightly described it as momentous. And the stark features of the decision include that it was taken in great haste on the morning of the 8th of March. It was taken without affording the appellants or anyone in their position whose trade stood to be cancelled any opportunity to be heard. And it was taken in circumstances and for reasons that were not contemplated by any of the respondents' own policies on the cancellation of trades. So we say the LME had no power to take that decision, and that it was in any event an irrational and unfair decision. This was, in our submission, regulatory overreaction and overreach on a grand scale. As for the evidence, you will of course have seen there is lots of evidence, even though you have been spared some of what was before the Divisional Court. But what
you could have been spared a good deal more, but still.
I am sorry about that, my lord. What you conspicuously don't have is any contemporaneous evidence of the reasons for this decision. There are some notes, short notes, that you may have seen, and just for your reference, it's a supplementary reference bundle at pages 703, 706, and 714. But they actually don't purport to set out the reasons for the decision. So the factual picture that the Divisional Court set out in the judgment is inevitably based on the key witnesses' recollection of the decision-making. Now, some of that evidence. It is really what one, I think, would best describe as assertion and speculation as to what might have happened in a counterfactual, assuming there was something legally wrong with the decision. Would the outcome nevertheless have been highly likely not to be substantially different? Going to the respondents' reliance, if they have to, on Section 31(2)(a) of the Senior Courts Act. Well, the Divisional Court, of course, didn't address that because they didn't get that far given the other conclusions that they reached. But I will, in due course, refer to well-established principle that refers to how such assertions about a counterfactual need to be treated with considerable caution. See in particular the Cava-Bien case that we may come on to. But then there's the question of disclosure, which I should briefly mention also before launching into our round one. There has been lots of disclosure too, as the respondents would emphasize, but there has also, unfortunately, been a troubling lack of disclosure in certain significant areas.
Well, before you spend too much time on this,
Yeah.
as far as I can see, we're not being asked to make any order. If we are being invited to say something rude in our judgments, we will have to be persuaded that there is some point in doing so. We are where we are, aren't we? You want to refer to the late disclosed documents. Nobody's suggesting you can't. We'll hear your submissions about them.
Yes.
But to spend time working out whether it is excusable, and if it's not excusable, how it came about, is not time well spent, is it?
I mention it really to register our concern and to explain that in our submission these disclosure materials were certainly plainly relevant, and if we had had them in the proceedings before the Divisional Court, we may well have sought permission to cross-examine. And all I ask is that the court should bear that in mind when you now come to evaluate those documents and the evidence by way of witness statement that went with them. It was troubling that one gets disclosure out of the blue in the Court of Appeal for the first time, and that we then had to ask for one of the documents mentioned in that disclosure, the so-called kill switch procedures, only disclosed after we had asked, even though that is a policy that goes directly to one of our challenges, namely to Mr. Chamberlain's view that the market had become disorderly. But I'll say more about it in due course. I would just add in relation to that that it was all the more disturbing to get that document only now, when Mr. Chamberlain, in his first witness statement, actually has a specific section headed LME policies relating to the suspension of the market and the cancellation of trades. And this policy was precisely a policy that falls into that category.
What are we supposed to do with a submission that says we may have sought permission to cross-examine? I mean, where does that take us in terms of the facts as found by the Divisional Court?
It simply means in our submission that your lordships would be right to bear that in mind when you judge what one derives from the recent witness statements and disclosure. That is where it goes.
Right. Well, let's nothing more about the late disclosure. So where are we going now?
Ground one of the appeal. This is where we submit that the Divisional Court was wrong in the emphasis it placed on what it called the contractual context. The court explained its approach in relation to that at paragraphs 133 to 138 of the judgment, And it may be worth just turning up paragraph 135 to get a flavour of what they had in mind and how they saw it. In paragraph 135 on page 132, they draw a distinction between this case and other judicial review cases, and they say this case is very different. Here, each of the Elliott claimants and James Street made a conscious decision to enter each trade and to do so under the LME rules. They did not have to do so to do this. They could have conducted their nickel trades elsewhere, including the over-the-counter market, or they could simply have abstained. They became subject to Trading Regulation 22 through their deliberate free choice and consent. And as your lordships may have seen, the significance of this approach was actually recognised by the Divisional Court itself when it gave permission for this appeal. It may be worth briefly turning that up.
We can if necessary, but we have it very much in mind.
Yeah.
They said this was the main point.
Yes, so
the main reason why they were giving permission. Yeah.
Significant for this case and more generally, and
yes.
Something that, as it were, permeated all of their reasoning. What I then propose to do is to make some observations about this as a matter of principle, and then touch, as we go through the other grounds of appeal, touch on where this comes alive in relation to those other grounds. The starting point, we say, as a matter of principle, is that, as was recognised and as is common ground, the respondents carry out regulatory functions when they act in the context they acted here. Regulatory functions with public law obligations, and they are, of course, also for these purposes a public authority under the Human Rights Act. And, no dispute at all, they're amenable to judicial review. Why are they so amenable? Well, because, as was emphasised in the Albatross case that I will take you to, when acting as regulators, they carry out a public function, and a function that is, as it was put in that case, woven into a system of governmental control of investment business, integrated into a system of statutory regulation. And the fact that market participants such as my clients become subject to that system by virtue of contract, in the sense that they're obliged to agree to abide by the LME rules through their contracts with their members who act on the exchange in relation to their trades, well, that does not in any way alter the nature of the function, nor is there any reason in our submission why it should alter in any way the court's supervisory approach to the exercise of that function. It's the nature of the function that always matters, not the mechanism through which someone becomes bound or subject to that function. This is, of course, a case that is a very long way removed from the kind of case you sometimes have when a public authority acts in a purely commercial capacity, seeking to enforce some private law right, when we know that sometimes issues can arise as to whether and to what extent public law standards apply. But when the LME cancelled the appellant's trades, they clearly did not take a commercial decision, but exercised a regulatory power. And there is case law from this court, the Bradley and Jockey Club case that I'll also invite you to go to, that says that even when the court is exercising a supervisory function over a disciplinary decision, purely as a matter of contract, even then, the standards that the court will apply, the supervisory approach that it will apply, will be no different from what it would do on judicial review. Well, if that's right in, as it were, a purely contractual case, where the court is exercising a contractual jurisdiction, as opposed to here, judicial review, well then that idea must apply a fortiori, we say. There's no basis for, as it were, diluting the public law principles that otherwise apply. Now, of course, we're not suggesting that context isn't or cannot be important. You know that context is frequently very important in law. For example, the gravity of the issue may be very important. That was emphasized in the Kennedy and Charity Commission case that the respondents referred to in their skeleton. So we entirely accept that, but what we don't accept and respectfully say was wrong was the divisional court's idea, which clearly was the contractual mechanism somehow undermines the standards of public law that would otherwise apply. And of course, the court below attached a lot of importance to the idea of consent, free consent to be bound by these rules. But we say all that one can legitimately infer from the consent through contract is that the appellants agreed that any regulatory decision taken against them or in relation to them would be taken in accordance with ordinary principles of public law and with the potential for the court to apply normal public law scrutiny to any such decision. There is simply no basis for inferring that the appellants agreed to some sort of lower or different standard or a lesser degree of supervision. And there's no reason of principle or authority to support that view.
Will you be showing us at appropriate times passages in the divisional court's judgment where they said that, for example, consent led to the conclusion that there was a dilution of the ordinary public law principles?
Yes, and they didn't use that phrase, but I absolutely will show you that where they make the point that the margin would be particularly wide because of contract. So as we go through, if it would assist at all, I can give your lordship now some paragraphs in the judgment, just the numbers, where this is particularly
No, I'm happy
evident.
for you to
Okay.
take your course.
Thank you, my lord. Then I'll come to it in due course. And as to the divisional court's idea that, well, the appellants had a free choice, they could have conducted their business elsewhere, see in particular judgment paragraph 135. Well, theoretically, that may be so, but even if it is, that still doesn't provide a good reason to somehow apply public law light. And the divisional court didn't, with respect, explain why that should be so. And in any event, it's hardly realistic to talk of the appellants having a free choice to trade or not on this market, given the huge significance of this particular market. There is no comparable market that the appellants could have chosen to trade on. And the idea of choice in our submission is problematic. Would one say that a firm that decides to offer its financial services in the city chooses to be subject to regulation by the FCA, and therefore somehow that has an effect on the public law standards by which the FCA is judged? In our submission, that would be an odd idea, and we say it's equally odd in this context. And nor is it right in our submission to speak of informed consent here, as the divisional court did, in the sense that there was nothing here by way of practice or precedent or policy to indicate that this kind of action might be taken in respect of trades agreed. In fact, the evidence indicates that the CEO of the LME, Mr. Chamberlain himself, was unclear as to the ambit of the LME's powers. For your reference, paragraph 223 of Chamberlain 1. And may I apologize for the fact that it will quite often, I think, be necessary to give you evidence references, but not actually ask you to turn them up now, simply in the interests of getting through where we need to get to. What Mr. Chamberlain said in paragraph 223, which is core supplementary, page 116, is that he says, towards the end of the meeting, and that's the meeting at 9 o'clock in the morning on the 8th of March, when the whole business of cancelling trades was discussed, he says, towards the end of the meeting, various powers that were potentially available to the LME and to LME Clear to cancel trades were considered. And we'll come on in due course as well to the evidence of the chief executive of the LME Clear, Mr. Farnham, who also makes that point that there was a whole discussion about whether to cancel the trades. And then consideration is being given to what powers there might be to do so. In fact, Mr. Farnham, and as I say, I'll get to that, but Mr. Farnham actually makes the point the decision in principle to cancel had been taken, and then there was consideration of the powers. Anyhow. So much for informed consent. Really not realistic to suggest that the appellants could have somehow anticipated what was done in this case, that such a power was there or might have been exercised in that way. And we come back to this idea that the LME is, of course, woven into the regulatory framework. It is a recognized investment exchange. It is woven into the EU-derived framework, and we'll have to look at some more of that in due course. But it's fair to say that the policy is plainly to treat it as a regulator in the normal way, and for there to be a policy of encouraging trade on such an exchange. That is also supported by the way in which private law remedies are severely curtailed. Section 291 of the Financial Services and Markets Act, which you have at Supplementary Authorities Bundle, tab 2, page 8.
Sorry, can I have the reference again, please?
Yes, it's section 291 of the Financial Services and Markets Act. Perhaps we should just turn that up. Supplementary Bundle 1, at least it's my bundle 1, tab 2, page 8.
So this is supplementary
Authorities Bundle.
Yeah. Oh, sorry.
Tab 2, page 8.
Which I've got 8 volumes of supplementary authority bundles. Which supplementary authority bundle are we in?
Okay, I'm afraid I only have 4, but it's tab 2, so it should be in the first one, I would imagine, first bundle, and it's page 8.
Yeah.
I'm grateful. So, section 291.
Lay a small bet on how many of these authorities we actually have to look at.
Well,
Okay.
I shan't respond by saying I'll do my best to look at loads and loads.
Yes.
Heading liability in relation to recognised bodies' regulatory functions. A recognised body and its officers and staff not to be held liable in damages for anything done or omitted in the discharge of the recognised body's regulatory functions, unless it is shown that the act or omission was in bad faith. But subsection 1 doesn't prevent an award of damages made in respect of an act or omission on the ground that the act or omission was unlawful as a result of section 6.1 of the Human Rights Act. And one sees the definition of regulatory functions. So it is certainly not the case that there are, as it were, as an alternative, readily available private law remedies against the respondents when they carry out their regulatory functions. Again,
You're not saying, are you, that this was a case of bad faith? So far as a financial remedy is concerned, it's Human Rights Act or nothing.
Absolutely, Mark.
Yeah.
Yeah. We simply make the point that given the curtailment of private law remedies, it would be all the more surprising if public law didn't play in the usual way, applying the usual standards, including the usual intensity of supervision. And there is one other factor that we submit also supports that view, which is that it's well recognised, and this is simply a general point, that there is a potential for a conflict of interest between the commercial interests of an exchange such as this and its regulatory functions.
Where does this point get you?
Where it gets me is that it is another factor that suggests that it would be very surprising if public law standards didn't carry their usual weight in this particular context. It points against the divisional court's idea that because this function applies through contract, you somehow have, as I've called it, public law light. I'm not going to make a meal of the point, but the reference to inherent potential conflict is in Article 47(1)(a) of MiFID II. You have that in Core Authorities Bundle 1, Tab 3, page 304. Particularly surprising against that background if it was a question of public law light. That then,
Did the divisional court use the phrase public law light?
no, my lord, they did not. Absolutely not.
So
But
that's your interpretation
yes,
of what the divisional court was doing.
yes, and I hope to show you exactly how that manifested itself in a way that did indeed amount to that because of the consistent refrain on
At some point,
every
we're going to
topic.
have to move from your general points, which are well made in the skeleton, about why public law light isn't the right approach, and actually see where you say they did it, because at the moment, we'll need some, I will speak for myself, I'll need some persuading that they actually did do it.
Apply public law light.
Yes.
Yes, so a very good example, if I may just give that now.
Well,
Or,
it's not so much,
yeah,
I'm not saying take me to it now, I'm just flagging up, for instance, like my lord did a few minutes ago. that,
yes,
I see the force of some of these
yeah,
points, but at the moment where they need to be, at some point, they need to be related to the actual reasoning of the court.
Absolutely. And
But you're going to come to that, so do it in your own way.
I will come to that, and I think, as my Lord Justice Singh has indicated, it's perhaps not helpful to give you a list of the particular paragraphs in the judgment now, although I would happily do so.
Well, all right, if you could just literally just, if you've got a list there, just write them down, and then they'd be useful to have them.
Yeah,
What,
thank you.
Namely?
So, paragraph 159, procedural fairness.
Yeah.
Paragraph 173,
Yeah.
intensity stroke scope of review and tame side. Paragraph 177, margin of discretion in relation to relevant considerations. Paragraph 200, irrationality. And then in relation to Article 1 of the first protocol, I think that's 239. Let me just double.
Well, don't worry. Okay, well that means that if we want a short summary of what the key passages will be for this submission, we have it. But anyway, you're going to take us to those passages in due course and perhaps fairly soon.
Yes.
You gave a reference a minute ago to somewhere where MiFID talks about inherent potential conflict.
Yes.
What was that, please?
So that's in the relevant EU directive MiFID II, Article 47(1)A, Core Authorities Bundle 1, tab 3, page 304.
Thank you very much. I think you said 46 before, which is what confused me. But
Oh, I'm so sorry.
if I look further down the
47.
page, I do see it. Thank you very much.
Two authorities then.
Yeah.
First, the Bradley and Jockey Club case that I mentioned, the one that shows that even if it's a completely contractual exercise of jurisdiction, the standards are nevertheless the same. Supplementary authorities bundle 2, I believe it would be for you, tab 16, page 678.
Tab 16, did you say?
Tab 16, yes.
Thank you.
Here we have a former jockey, Mr. Bradley, subject to the rules of racing, so by contract bound to certain disciplinary powers that the Jockey Club exercised in a way that he did not like, issued proceedings in the High Court claiming breach of contract, referring to an alleged implied term that the Jockey Club would carry out its functions reasonably and fairly, and imposing a proportionate sentence. Now, we can go, I think, straight to the judgment of the Master of the Rolls, Lord Phillips, with whom Lord Justice Buxton and Scott Baker agreed, at paragraph 17, page 683, where Lord Phillips agreed with and commended the analysis of Mr. Justice Richards, as he then was in the court below. And one sees a citation or a quote from Mr. Justice Richards' judgment at para 17, and it's paragraph 37 of the Richards judgment, which is important. And particularly right at the end, bottom of the page, last two lines on page 683, I would consider it surprising and unsatisfactory if a private law claim in relation to the decision of a domestic body required the court to adopt a materially different approach from a judicial review claim in relation to the decision of a public body. In each case, the essential concern should be with the lawfulness of the decision taken, whether the procedure was fair, whether there was any error of law, whether any exercise of judgment or discretion fell within the limits open to the decision maker, and so forth. the supervisory role of the court should not involve any higher or more intensive standard of review when dealing with a non-contractual than a contractual claim. So, making the important point that even if there's a disciplinary power being exercised pursuant to contract and the court acts pursuant to contract, the standards are no different from what would apply on judicial review. So we particularly fasten on that. Given that statement of principle, it would be very odd if the situation were not the same in our case, we say. The second case, I should just say the Bradley case was not mentioned before the divisional court because it hadn't emerged from the respondents' arguments before that court that the contractual context was going to be given so much significance. That certainly came as a surprise to us when we saw the judgment. So that's just to explain how Bradley was not referred to and, of course, not analysed by the divisional court. Then the second case I wanted to show you was the Albatross case. This is Core Authorities Bundle 1, Tab 5.
Sorry, can you just bear with me?
Yes.
I've got to put this one away
Yes.
and get the other one out.
Absolutely.
If you don't mind.
I'm sorry, my lord.
So, for which volume?
Core Authorities Bundle 1, it should
Yes.
be Tab 5, page 397.
Yes, thank you very much.
I'm just very helpfully reminded that I missed out when I gave the list of passages where the divisional court's reference to the contractual context is particularly important. I missed out A1P1 paragraphs 246 to 249. So if I may add that in.
Thank you.
So the Albatross case then was an earlier judgment of Mr. Justice Richards, as he then was, where the issue was whether...
You didn't say as he then was. Too much of it goes on in this court. We know who Mr. Richards is.
I'm very, very grateful to be told that, and I won't have to think about that maybe ever again. So the issue there was... was the LME in that particular context amenable to judicial review? And of course, there's no dispute about that here, but it's nevertheless important, we say, to see how the judge approached that issue, and particularly that emphasis on weaving its regulatory function into the regulatory framework. So there, the claimant Albatross was a warehousing business bound by the LME rules. LME had imposed certain sanctions on them for breaches of the rules, and they then sought to challenge that by judicial review. It's paragraphs 17 to 29 of the judgment, starting at page 408. But we can go, I think, straight to paragraph 23 on page 410. Where the judge says, despite those competing submissions, I do not think that the broad principles are in dispute. The essential question is whether, in exercising disciplinary powers over listed warehouses, the LME is performing a public function. The fact that the powers are exercised pursuant to a contractual relationship between the LME and the warehouse is a factor telling against the performance of a public function, but it is far from decisive of the question. It's necessary to make a broader assessment based on all the circumstances of the case, and in particular on the extent to which the powers can be said to be woven into a system of governmental control. And then if we scoot on to paragraph 27, page 412, and perhaps I can invite your lordships to read para 27 up to the point where reference is made to the Lautro case. I'd be grateful.
Yes, thank you.
Thank you. So that was the position in relation to the LME in that case.
Sorry, can I ask, was Albatross cited to the divisional court?
No, it wasn't, or certainly it may have been mentioned in some skeleton or other, but it certainly wasn't mentioned for this purpose, or as I recall, referred to in oral submissions, again, because we had not anticipated, in light of what the respondents had said, that there was an issue along these lines. So we say, just as in Albatross here, important public function being carried out, no reason why it should matter. That's really the point, that my clients became bound to these rules by contract and therefore couldn't avoid the exercise of regulatory power. Another way of putting it, which perhaps fits more neatly with the divisional court's own language, is that in the light of these authorities and the other submissions we have made, there is no good reason why the LME and LME Clear should have a broader margin of discretion in taking a regulatory decision than they otherwise would, simply because of the contractual basis for them to carry out that function. That then completes what I wanted to say about ground one for now. And if I may, I'll turn to our ground two.
Oh, right. You've obviously thought about this, and that's fine. I'd rather assume you would now, having set out the principles, take us to the passages where you say they didn't follow those principles. But you're going to do that later, are you?
I thought it might make more sense to do that in conjunction with the other points that we then make.
Okay. No, I'm not trying to put you off your course. Just for a moment took me by surprise. And we got the list, so that's fine. Yep.
Yes, I think they may...
No problem. Say no more about it.
All right, thank you, my lord. So, ultra vires, then. We say on a proper construction of the relevant rules or rule, the LME didn't have the power to cancel our trades in the circumstances that prevailed on the 8th of March 2022. So the decision was ultra vires. And there are two variations on this theme. One, that the extent of the cancellation power in Trading Regulation 22.1, which is the key provision, the extent of that power is defined by reference to retained EU delegated legislation which implements the MiFID II directive.
That's the RRR.
RTS 7.
Oh, it's not. Sorry, I thought I was being clever. No, I mean...
Well,
okay. Yes, I
also,
know exactly what you mean. I just
RRR is part of it too, so
no,
you are definitely...
But it was... Yeah, okay. Just for my note, really, to get down quicker. Yep.
And secondly, further alternatively, we say there was, in any event, a mandatory requirement under said retained delegated legislation to have a published policy that would cater for cancellation in the circumstances we're concerned with here. The Divisional Court dealt with that in paragraphs 139 to 149 of the decision, and they...
Sorry, which paragraphs?
139 to 149, the judgment. And they essentially rejected both points by briskly saying, well, none of this applies to these particular trades because the delegated legislation only applies to algorithmic trading, that is specifically to trading systems that through which you can carry out algorithmic trading, matching offers and bids. Our answer is with respect to them that their view, and I'll show you of course in a moment, rests on a misunderstanding of the scope of the delegated legislation. It does apply, we say, relevantly to the LME as a recognized market, as a, regulated market. It doesn't simply apply to the LME's algorithmic trading system, which is called LME Select. So, if we look at the judgment, paragraphs 139 to 149, we see that, and particularly at paragraph 145 on page 134, they considered that it was clear, this is the middle of the paragraph, that the premise for RTS 7...
So which paragraph?
Paragraph 145, page
Thank
134. I should read this bit. We do not consider that Article 18 has any bearing on the exercise of the TR22 power in circumstances such as those existing on the 8th of March. While the scope for regulatory technical standards under Article 48.12 of MiFID II is widely cast, we consider it to be clear that the premise for Regulatory Technical Standards 7 was Article 48.12g, i.e. the requirements to ensure appropriate testing of algorithms so as to ensure that algorithmic trading systems cannot create or contribute to disorderly trading conditions on the market. Delegated Regulation EU 2017-584, that is RTS 7, is therefore directed to algorithmic trading.
Which of these paragraphs is dealing with the need for a published policy? It may be that that's referred to in some of these articles, but the phrase
yes.
Published policy doesn't appear anywhere in these paragraphs, and
No.
maybe it's all a bit compressed.
It is. That is in Article 18.3 of RTS 7 that I will show you in a moment.
So give me the reference again.
Article 18.3.
Thank you.
And I should say the substantive requirement, or rather the substantive parameters for the exercise of a power to cancel trades that we rely on is in Article, or are in Article 18.2 of RTS 7.
So when they say we do not consider that Article 18 has any bearing, that's equivalent to saying that the need for a policy doesn't have any bearing on this because it's dealing with something different.
It's the equivalent of saying that, and it's also the equivalent of saying, and insofar as Article 18.2 limits the circumstances in which trades can be cancelled, that has no bearing either. So it rejects in one fell swoop both of those points.
Thank you very much.
By saying it's all about algorithmic trading, which is not what applied in the case of the Elliott trades. That then invites us, I think, to go straight to Article 48 of MiFID, to make good the point I made that actually what Article 48 of MiFID has in mind is regulated markets broadly, not just algorithmic trading. I think that much is common ground. Article 48 of MiFID applies across the board to regulated markets. And we say, and I'll take you to the relevant provisions in a moment, that there's no good reason to believe that the delegated legislation under MiFID, RTS 7, is cast more narrowly so as to only apply to algorithmic trading. So you have Article 48 at Core Authorities Bundle, tab 3, page 234. Article 48 at page 305. Article 48(1), if you have that on page 305, sets the scene in terms of requirements being imposed on regulated markets such as the LME. Member states shall require a regulated market to have in place effective systems, procedures and arrangements to ensure its trading systems are resilient, have sufficient capacity to deal with peak order and message volumes, are able to ensure orderly trading under conditions of severe market stress, are fully tested to ensure such conditions are met, and are subject to effective business continuity arrangements to ensure continuity of its services if there is any failure of its trading systems. Flesh on the bones of that is then put by, among other provisions, Article 48(5), which is important.
We should just notice the title, shouldn't we, of the whole article?
Yes.
Is the term systems a defined term?
No, my lord, I don't believe it is. And it is used in slightly different ways in different contexts, I'm afraid. Paragraph 5, then.
Sorry, just while I'm interrupting you, is there a recital that can be clearly identified as the recital underlying Article 48, or doesn't it work that way?
My lord, that I would have to check, but what we certainly have is recitals in RTS 7 that helps us along the way.
Okay, no problem. You're about to take us to 48(5), did you say?
Yes. Member states shall require a regulated market to be able to temporarily halt or constrain trading if there is a significant price movement in a financial instrument on that market or a related market during a short period, and, in exceptional cases, to be able to cancel, vary, or correct any transaction. That is the basis, it is common ground for TR 22(1), the trading regulation that was relied on here. And it was accepted before the divisional court that that regulation had to be read as referring to cancellation only in exceptional circumstances, as per Article 48(5). You have that regulation. I'm not sure if you've had a chance to see it, but you have 22(1) in tab 14 of the core supplementary bundle.
Hang on 1 second.
Yeah.
Which bundle are we in now?
I'm afraid we're now in the main bundle, the core supplementary bundle, so not authorities, but the main hearing bundle, core supplementary bundle, tab 14, it starts at page 296.
Sorry, you better wait till I find the bundle.
Yeah.
Yeah.
I'm very grateful. TR 22.
Which tab did you say?
Tab 14. And the relevant page for the regulation is page 312.
This doesn't have a front page, doesn't, but do we need to see what the front page of the reg looks like?
I doubt that will assist particularly.
Oh, I see. Sorry. No, I've misunderstood what this is. No, don't worry. Yep.
The relevant trading regulation.
Yes, no.
Yeah, 22.1.
Yeah, I have it.
And particularly as to the power to cancel trades, one sees it reads, where the exchange considers it appropriate, the exchange may cancel, vary or correct any agreed trade or contract. Now, it's quite important that it was common ground before the divisional court that because 22.1 is intended to give effect to the regulatory framework, you read this as confined to cancelling trades in exceptional circumstances, not just where the exchange considers it appropriate. So,
do we also read it as contemplating that the exceptional circumstances where that may be appropriate may be connected with the significant price movement during a short period, which is referred to in the preceding sentence as giving rise to the possibility of halting trading?
my Lord, to the extent that that might be taken to indicate that that alone would somehow enable the cancellation of trades, we would say, no, that is the general context that the trade halt power is concerned with. Cancellation is a very different thing. And as I'll show you in a moment, Article 18.2 makes it clear that only in specific circumstances, we say, of malfunction of systems, etc., can there be cancellation. So I'm just anxious to make clear that we wouldn't accept that it's simply a question of price volatility and then you can cancel trades. Absolutely not.
But just as a matter of structure, what I think you're saying is that the two sentences of 22.1 are dealing with different things, although they're obviously broadly in the same area, which is why they're in the same rule.
Yes.
First is temporarily halting or constraining trading.
Yeah.
And the second is cancelling, varying or correcting trades or contracts.
Yes. Which distinction links to a point I'll come on to in due course as well, a very important one, that it absolutely does not follow that because there may be reason to halt trading or suspend a market, there is therefore an entitlement to cancel trades. These are very different things, I emphasize, and that's at the heart of our case.
But if we go back to Article 48.5,
Yeah.
on which Trading Regulation 22.1 is based,
Yeah.
the reference to significant price movement giving rise to halting trading and, in exceptional cases, to be able to cancel a transaction is all in a single sentence, which suggests that there's no clear, rigid division between two different concepts.
Well,
Is it not?
it may be that we are talking about broadly the same context in the sense of the whole point of this scheme being to ensure orderly trading, but I emphasize we are absolutely not, despite it being one sentence, absolutely not accepting that cancellation would follow as an additional power simply because the power to halt might have come into play. And again, I come back to, well, I hope to show you that from RTS 7, making that particularly clear.
Well, clearly something more is required for cancellation.
Clearly
because
something.
You have the additional requirement of exceptional circumstances, whatever they may be, which, in express terms at any rate, does not apply to the power to halt trading.
Yeah.
But it's in the same area, I might think.
But circumscribed in a very clear way, we would say.
Well, otherwise than by reference to exceptional circumstances.
I'm sorry, my lord.
Otherwise than by reference to, you say circumscribed in a very clear way.
Yeah.
By what?
By the provisions that I need to come on to in a second, in RTS 7,
Yes,
which is our Article 18.2.
Okay, well, you're going to come to this.
Yeah. And it also is about the inherent purposes for which one might want to halt trading, and whether whatever purpose may justify that could also justify cancellation. And in our submission, there's a very big divide between the two. One simply does not follow from the other. Article 48, then, I was going to take you also to Article 48.12, page 307.
Can we put Rule 22.1 away?
Yes, as long as it's nevertheless etched on your brain.
It's etched in my mind.
That is good.
Certainly.
Yes.
Not you don't ask me to repeat it. So where should we be going?
Article 48.12, just to complete the picture.
Yes, but I put that bundle away, so you're going to tell us where it is.
Yes, so that is Core Authorities Bundle 1, tab 3, page 307.
Thank you. So 48.12.
Yes.
Yep.
ESMA, the European Securities and Markets Authority, shall develop draft regulatory technical standards further specifying A, the requirements to ensure trading systems of regulated markets are resilient and have adequate capacity. And then I would invite you to scoot along to subparagraph G, the requirements to ensure appropriate testing of algorithms, etc. That, of course, was the subparagraph that the Divisional Court fastened on as the premise, that's how they put it, for RTS 7.
Will you just give me a moment, Tess?
Yes.
Obviously, B to F, the details don't matter. I just want to see the sorts of things they are. Yes, thank you.
Our simple answer then to the Divisional Court's point that it was all about Article 48.12G is that when one looks at the relevant provision on RTS 7, we rely on Article 18, and I'll take you to that, you will find that there is a reference to Article 48, but not to Article 48.12G. And one sees that from Core Authorities Bundle 1, tab 4, page 388. It's the same bundle, next tab, I hope, page 388. heading Prevention of Disorderly Trading Conditions, Article 48.4, 5 and 6. No reference to Article 48.12g there. And if we then look at the preamble to RTS 7 as a whole, page 375 of that same tab, one sees a reference to the directive, that's MiFID, having regard to Directive 2014-65 EU, about halfway down the page there. And then this reference, and in particular points A, C and G of Article 48.12 thereof. So 48.12 absolutely is mentioned, including 48.12g, but not only. So we simply do not see how the divisional court arrived at the conclusion that it was only Article 48.12g, dealing with algorithmic trading, that was, as they put it, the premise for RTS 7. One just can't read that out of the references that we have seen. And if that is right, then the key reason for the lower court dismissing our challenge based on Article 18 RTS falls away. And it would be very surprising, we say, in any event, if RTS 7 was intended to be solely limited to algorithmic trading, given that Article 48 of the directive is not such limited in such a way.
But isn't this delegated regulation we're looking at all about algorithmic trading?
Not only, my lord.
Well,
not only.
The recitals seem to be full of it. The heading on page 378 is General Organisational Requirements for Trading Venues Enabling or Allowing Algorithmic Trading.
Yes, but the LME is such a body, and that's important. So absolutely we accept that there are references aplenty to algorithmic trading. But if you look at Article 18, for example, it is not so limited. And when one refers, or one speaks, as in Recital 1 to RTS 7, of trading venues that enable algorithmic trading, that is apt to apply to the LME as a regulated market. A regulated market is the same as a trading venue, we are told by Article 4, subparagraph 24 of MiFID II. And so one reads that reference to trading venues as
Sorry,
a
where are we
reference.
reading where trading venue? Sorry, in the second line of 48.
So I was looking now at the preamble to RTS 7.
What I call
Picking up my
recitals.
Lord
Yes.
Lord Justice Mayall's point. Yes.
Yes, I thought my
recitals.
Lord's point was actually about the title of chapter 1. But maybe I misunderstood him.
Well,
Sorry.
it's about both the recitals and the title.
Well, the same point
Yes, sorry.
applies in our submission.
You gave a reference to the source of the proposition that trading venue is the same as regulated market,
Yes.
but I'm afraid I didn't keep up with you.
No,
I don't
not
know
at
what the
all.
reference is.
That's Article 4, subparagraph 24 of MiFID II.
Thank you.
Core Authorities Bundle, tab 3, page 245. And I would just also invite you to look at Recital 3 to RTS 7, same bundle, page 375, which one sees in the middle refers to specific organisational requirements should be laid down in respect of regulated markets, multilateral trading facilities and organised trading facilities, allowing for or enabling algorithmic trading through their systems. Well, that's precisely what the LME does. It does allow that through its system known as LME Select. And going then to Article 18 again at page 388, one sees the reference at the beginning to what trading venues shall have. Trading venues, we say, being the equivalent of regulated markets, i.e. the LME.
So what you're asking is,
So I'm asking you...
what particular part of one are you referring to?
18. So 18.1 provides for arrangements that must be put in place to prevent disorderly trading and breaches of capacity limits. It says at least the following arrangements a trading venue must have. And then at 2, which is important, for the purposes of paragraph 1, i.e. for the purposes of those arrangements, trading venues shall be able to, and then we can go to C, operate a kill functionality to cancel unexecuted orders. And then if we go to D, which is what is really relevant for our purposes.
Well, sorry, I just want to see the circumstances.
Yeah.
Yep.
Cancel or revoke transactions in case of malfunction of the trading venue's mechanisms to manage volatility or of the operational functions of the trading system. Those are the circumstances in which RTS 7, Article 18.2 envisages that it should be possible to cancel trades. Transactions is the word used. We say that clearly includes the sort of trades that the appellants had. Now, the respondents say, well, but isn't this all about minimum requirements? And they point to the words, should at least have the following arrangements in Article 18.1. Well, we say 18.1 deals with arrangements. 18.2 then deals with something different, which is what is required in terms of powers in relation to such arrangements. One does not have the words at least in relation to Article 18.2 or in Article 18.2. So we say Article 18.2 does set the parameters for or explain what is meant by cancelling in exceptional circumstances in Article 48.5.
So you say that these are the only circumstances in which the power to cancel in Trading Regulation 22 can be exercised. Is that right?
That is right. Yeah. And we emphasize that it is common ground that these circumstances were not in play in relation to the cancellation decision in our case. That decision did not fall within those circumstances. And we say in any event, as the respondents say, this only represents the minimum of what is required. Well, we have been told expressly in the respondent's skeleton argument that Trading Regulation 22.1 is intended to give effect to the regulatory framework. That is the context of that regulation and, as it were, the mischief that it is designed to deal with, if one can call it that. And on that basis, we say one may surely infer that Regulation 22.1 is limited on its proper construction to the requirements, even if they are minimum requirements, as set out in Article 18.2.
What does kill functionality in paragraph C of this article mean? I mean, why doesn't it just say trading venues should be able to cancel unexecuted orders? Is that some technical term, something that a computer does automatically, or what?
My Lord, I'm not aware of any particular definition of that term. We will come on to a policy called, well, the one I mentioned earlier, kill switch procedures in a moment. But in terms of it having a specific meaning, I'm not aware of that, my Lord.
But I mean, if it doesn't have a specific meaning, then isn't paragraph C what the LME did? It cancels unexecuted orders following a suspension of trading initiated by the market operator. Looking at,
but my Lord, for our purposes, it's Article 18.2d that is relevant, because we are not concerned with orders. We are concerned with transactions where the provision is cancel or revoke transactions in case of malfunction of the trading venue's mechanisms to manage volatility or of the operational functions of the trading system. So we are not concerned for the purposes of our cancellation decision with C, but rather with D.
What, because these are not unexecuted orders submitted by a member?
Absolutely not. They are transactions, and that's, of course, very important. Mr. Chamberlain himself, just picking up that point in his evidence, for your reference, it's his first witness statement, paragraph 50, says, the precursors to any individual trade are typically referred to as orders.
Just, would you give me the reference again?
Paragraph 50 of Chamberlain 1, Core Supplementary Bundle, tab 3, page 71. And also Mr. Farnham.
So what is an order? Is that where somebody is simply saying, I'm willing to trade this quantity at this price? Is anybody interested?
Effectively, yes. Yes.
So
but here,
it's an offer or a bid.
Yeah, but here we are concerned with an agreed trade where you have a willing buyer and a seller and all the commercial terms have been agreed. Mr. Farnham also accepts that an agreed trade is a transaction. For your reference, paragraph 40 of his first witness statement, Core Supplementary Bundle, tab 4, page 156.
I'm sorry to bang about this, but if an unexecuted order is simply an offer, then this must be talking about algorithmic trading, mustn't it? Because that's the only kind of offer which you would need to operate a kill function to stop. If you simply halt trading, then nobody on the market is going to be accepting offers in person. It's only if the computer algorithms have been set up to do it automatically.
Well, I'm not technically gifted enough to say that that would necessarily be so, that it would only be where you have a computer system actually matching offers and acceptance by algorithm. It may be that one could conceive of a system where you have offers that are otherwise put through a computer, but not quite in that way, my lord. But at any rate, as I say, we are within subparagraph D.
Is that common ground?
No, I believe the point is taken against us that we were concerned with orders. We say that's a thoroughly bad point. In fact, if one were to go back to TR 22.1, one would see that the wording of that provision refers to any agreed trade or contract as being the potential subject of cancellation. So TR 22.1 doesn't actually use the word transaction. But TR 22.1, it is clearly accepted, and indeed that is the LME's case, applied to the cancellation, in this case, of our trades. Given that TR 22.1 is intended to implement the EU law-derived regulatory framework, it is tolerably clear that it treats agreed trade or contract, the words that it uses, as the equivalent of transaction.
Let's just be clear about this. You say it's clear because it's intended to implement the EU legislation, but this isn't a matter of vires. It would be perfectly possible for the London Metal Exchange to have slightly different powers than those prescribed by or required by the EU legislation. It's simply a matter of construction that when construing the rules, they are likely to be intended to go as far as, but no further than, the regulatory requirement. Is that how you put it?
We certainly put it in the way your lordship just formulated it, but our very first submission is that if, as we say, Article 18.2 does actually, by further specifying, set out the parameters, the outer limits of the circumstances in which the power to cancel can come into play, then the domestic body cannot go beyond that.
Oh, so it is a matter of vires.
It is a matter of vires, and even on the alternative, somewhat alternative submission, that it's a question of how you construe TR 22.1 in the light of the regulatory framework, it is also a question of vires. Because if on its proper construction the rule does not allow cancellation in these circumstances, then that would be ultra vires.
Sorry, which rule?
TR 22.1.
Oh, well, of course.
Yeah.
But I'm talking about the extent of the power granted, the power to cancel, granted by Rule 22.1. And you are saying that if there is a power to cancel which isn't constrained in the way you say the is provided for in the EU legislation, then the rule is unlawful, or ultra vires, if you like. But I just wonder why that is so. That the exchange doesn't get its powers directly from the EU legislation.
I think, my lord, the answer is that it probably comes down to the construction of the rule in the end, because everyone accepts that the rule must reflect the EU law framework. So if the EU law framework...
Well, it must at least comply with the EU law framework.
It must comply with that.
It must be but it doesn't necessarily... must comply in the sense it must do at least what the EU law framework requires and mustn't contradict it.
Yes.
But if it goes further than is required by the EU law
then it
framework
must be...
and doesn't contradict it, then it's just down to your saying, well, it's unlikely that that would be the case. It's an aid to construction, in other words. It's not a saying that it would be unlawful.
It's an aid to construction, but of course if it purported to go further than EU law allowed, then one would have to read it down in that.
Yes, I understand that, but that's what I meant by prohibited.
Yes, yes.
But it's perfectly possible that EU law has a series of minimum requirements And that doesn't mean that in an area where it hasn't said you may only do this, you do something more, that that's unlawful.
If that is the case.
Yes, well, okay,
Yeah.
thank you.
But we say the words further specify, which are used in Article 48.12, indicate that what you then get by way of further specification from ESMA in RTS 7 is intended to set the parameters, no more, no less. But as I say, if we're wrong about that, then in any event we say, well, even if it's just this is what is required by EU law, given that TR 22.1 was specifically introduced to comply with the regulatory requirements, we say you read it as referring to those requirements.
Yeah. Well, I understand that way of putting it. I just wanted to check whether that was the only thing you're saying. I think you made it clear it isn't the only thing you're saying.
Yeah, thank you. Article 18...
It would be surprising, wouldn't it, if a power expressed to be available in exceptional circumstances were tightly constrained by legislation, because that would mean that in a situation where the market was facing potential catastrophe, the regulator would not be able to take necessary action to prevent that catastrophe unless it could bring itself within the tight constraints.
Well, my lord, we wouldn't, with respect, agree with that. There is the important interest of transparency and foreseeability, which, of course, is an important principle of EU and domestic law. And what you have in Article 18.2 of RTS 7 is, of course, something to design to bring clarity and certainty and foreseeability to the circumstances in which such a broad power might be exercised, to avoid arbitrariness and to enable people to regulate their conduct, having an idea as to the kind of circumstances in which it might be thought we have such an exceptional case that we need to exercise this very draconian power. So that entirely goes hand in hand with the whole point of Article 18.2, the importance of transparency and foreseeability. So it entirely fits with that principle in our submission that you do have something that sets the parameters, no more, no less, of the power. We know what it needs to relate to, malfunction of systems, etc. There's still scope for judging whether it's an exceptional situation, but you get at least the particular context in which the exceptionality may arise. Perfectly sensible and desirable in our submission.
Can I ask you about a different, you may be about to come to this. It was the submission about there needs to be a published policy.
Yes.
Where do we find that requirement?
I was just going to come to that. It's Article 18.3, page 389, same tab, same Core Authorities bundle. Tab 4. Trading venues shall set out policies and arrangements in respect of, and if we go down to subparagraph F, cancellation policy in relation to orders and transactions, including timing procedures, reporting and transparency obligations, dispute resolution procedures, measures to minimize erroneous trades. And then at 4 of Article 18, trading venues shall make public their policies and arrangements set out in paragraphs 2 and 3.
Is this limited to or linked to paragraph 1, or is it a freestanding requirement?
Well, we say to the extent that the respondents are right in their argument that Article 18.2 doesn't exhaustively specify the circumstances in which it's possible to cancel trades. 18.3 does provide a further and, in that sense, freestanding obligation to have a policy that is published. It would be extremely odd, we say, given the importance of transparency in this context, if this were to allow that, well, you have a policy only for those things that are set out in Article 18.2, but if you're allowed to choose to have a broader cancellation policy, if you are, contrary to our first submission, then you don't have to have a policy under 18.3. That makes no sense in our submission.
Well, can I flag up 2 points which may be more for Mr. Crowe to address in due course, and they may be bad points anyway. But one that occurs to me is paragraph 2 begins for the purposes of paragraph 1, whereas paragraph 3 does not have any such link. And,
yes.
and the second point is that paragraph 1 provides trading venues shall have at least the following arrangements, whereas paragraph 3 simply says trading venues shall set out. It doesn't use the word at least.
No. So
that may or may not be significant, but I just want
yeah,
to
no, I agree, my lord.
I'm intrigued at the moment.
Well, that supports our submission, which is whether or not we're right or wrong about Article 18.2. Article 18.3 does require a published policy, which it is common ground the LME did not have in the sense of a policy that covered this momentous decision.
Yeah. But might it be said that almost by definition, you're not likely to have a published policy dealing with exceptional circumstances?
My lord, that wouldn't be right if one were to say that, because it's really the point I attempted to make in response to my Lord Justice Mayles a moment ago. It's important and certainly possible and sensible, we would say, to have a policy that sets up the sorts of circumstances in which exceptionality might arise. All in the interests of foreseeability and enabling people to arrange their affairs and conduct and to avoid arbitrariness. Now, I've been talking about the importance of transparency. Can I just give a reference to that? Specifically in MiFID Article 47.1d, which speaks of precisely of transparency. You have it in Core Authorities Bundle 1, tab 3, page 304. May be worth just briefly turning that up. Member states shall require the regulated market at D to have transparent and non-discretionary rules and procedures that provide for fair and orderly trading and establish objective criteria for the efficient execution of orders. And perhaps just for your note, we also have an emphasis on this in the domestic recognition requirements regulations, paragraph 4.2AA1.
Paragraph
4.
Is that regulation 4?
2. I'm sorry, Mel.
Regulation 4?
No, this is paragraph 4
right.
of the schedule
Oh, I see.
to the recognition requirements regulations. Basically mirrors what we have seen in Article 47.
Just for the note, where do we find that?
Core Authorities Bundle, tab 1,
Yeah.
page 30.
Thank you.
My lords, I'm acutely conscious of needing to cover quite a lot of ground. So if I may, I will then move on to and take briefly what we say about the effect of the failure to have a policy,
Yes.
if that is indeed a breach of Article 18.3, as we say it is. The authority we rely on is called McGrath and Camden, and I hope I may be forgiven for not inviting you to go to it, but just tell you what we derive. You have it at Supplementary Authorities Bundle 3, tab 47. I think it may be your bundle 5, I'm so sorry.
Well, I'm afraid we better, because it sounds like maybe quite important. Supplementary authorities.
Tab 47.
It is indeed 5. I've got to find it. Yep.
Yeah. So, in that case, Mr. Justice Holgate had a look at the consequences that might follow when there is a requirement, in particular a procedural requirement, or whether one describes it as procedural or not, but anyhow, a requirement that, say, information needs to be provided, as in that case, a question of whether a taxpayer was liable to pay a levy when certain information that the statute had said needed to be provided was not then provided, and the question was whether that rendered the notice of demand invalid. And at paragraph 52, Lord Justice Holgate then analysed this. So if I could invite you to look at paragraph 52 on page 1840. I'm so sorry, 1848, forgive me.
Yes, well, that looks fairly uncontroversial, but
Yes.
the first step is the important one.
What did the legislature intend?
Yes.
Yes. So, in our submission, what the legislature must have intended here to give the requirement of Article 18.3 any teeth, it is that it would not be open to the regulator to exercise a power unless it had the requisite published policy in place. Otherwise, that requirement risks becoming a dead letter, particularly when a power such as this to cancel trades is, of course, a power potentially to interfere, certainly with protected legal interests, but as we say, also fundamental rights, as in property rights, and may have extraordinary, far-reaching consequences.
Even if you were not right on that immediate submission,
Yeah.
would you submit that that does become a requirement and a critical requirement under A1P1? Because it can't, unless, assuming there is a possession,
Yes.
and assuming there is an interference with the possession,
Yes.
do you submit that it cannot be in accordance with law if it's not subject to a published policy? So even if in
Yes.
purely domestic law terms,
Yes.
you might be wrong. I'm not saying you are,
Yeah.
but do you make that alternative submission?
That is certainly part of our case too, that Article A1P1 contains within it that important requirement provided for by law, you need foreseeability, etc., which absolutely links to this point about the lack of a policy. Yes.
Well, A, lack of policy, B, lack of published policy.
Absolutely, lack of published policy. Yes, that's what I mean. Yes. So that, well, part of the function of that is, of course, to prevent arbitrary action, but it's, again, I don't want to repeat myself, it's to enable persons to regulate their affairs, knowing what may possibly happen in certain circumstances, having an idea of what may occur.
Yeah, I didn't want to take you out of order, but I just wanted to flag up that may be an important juncture in the argument later in the day, where we may have to come back to this.
I respectfully agree, yes. Yeah.
Right, thank you. So that's effective failure to have a policy.
Yes. And
anything else on that?
Only to say that if we were wrong on the first part, as in did the legislature intend total invalidity, and I'm leaving A1P1 to one side now, then we say alternatively, we fall within Mr. Justice Holgate's second category, i.e. where in the circumstances it would in any event be right to say invalidity follows. And here one also takes into account the risk of prejudice to market participants. Well, in fact, one takes that into account on the first submission also. And the prejudice, we say, is obvious because market participants were not able to hold the LME accountable at any stage by reference to a particular procedure or criteria that one might expect to have been set out in a policy. That then brings me to the final limb of our argument about ultra vires and the need for a policy, but it's an important part to add in to the submission so far. It's Trading Regulation 13.1, which you have in Core Supplementary Bundle, tab 14, page 310. At 13.1, the exchange may, in certain circumstances...
Sorry, again.
Yes. No, my fault.
Where are we?
So we're in the Trading Regulation.
Yeah, so which bundle are we in?
Core Supplementary Bundle, Hearing Bundle, this is not the authorities.
Yeah.
Tab 14,
Yeah.
page 310. So, Regulation 13, headed Trade Invalidation and Cancellation. 13.1, the exchange may, in certain circumstances, invalidate transactions in accordance with a relevant procedure established by notice. We say what that means is, and it states a general requirement, is that if the exchange is going to invalidate transactions, then it needs a policy in order to do so. That's the reference to in accordance with relevant procedures established by notice. Now, the Divisional Court rejected this argument at paragraph 142 of the judgment, basically saying, well, TR 13.1 doesn't say anything useful about TR 22.1, which is available on its own terms. And the respondents basically echo this, as I understand their submissions from their skeleton. They say, well, they're two separate rules. We respond that, of course, it's trite law that one generally construes a framework of rules as a whole, including where there has been amendment. And I should say the chronology is TR 13.1 was introduced in 2016, and then TR 22.1 in 2017. But we say, again, bearing in mind that important principle of certainty and transparency, and just leaving RTS 7 to one side, and indeed A1P1, for the moment, bearing that principle in mind, surely paragraph 13.1 should be read as also importing a requirement of a policy in relation to 22.1. And it's notable that in relation to the suspension power in 22.1, if you turn that up briefly, one sees there is also a reference to in accordance with the relevant procedures established by notice. And we say it would be extremely odd if the lesser power to halt trade or suspend trade required a policy, but the far more draconian power of cancelling trades or transactions would not. And so for those, I hope, straightforward reasons, we say here is another route to the point that a policy was required, and without one, the decision was ultra vires.
References according to the relevant procedures established by notice.
Yes, we say...
Doesn't that not just mean what steps you have to take to do something and give effect to it?
My Lord, we say certainly on a purposive construction, but even actually just looking at the natural meaning of the words, it is apt to include circumstances stroke criteria for doing whatever it is proposed. Otherwise, it wouldn't really serve a sensible transparency purpose, which again, if you look at 22.1 and the reference there to procedures by notice, it would be extremely odd, given the whole regulatory background, if that wasn't intended to refer to a policy which sets out the circumstances in which the power can be exercised. And the same must be right, we say, a fortiori, for the much more draconian power to cancel. I was going then to move on at as much breakneck speed as I can muster to procedural fairness. Or perhaps the move won't be at great speed, but it's a hugely important point in our submission, but I hope to be able to take it fairly briskly. Unless I can assist further for the moment on the ultra vires points.
Sorry, what you were obviously asking us something I didn't.
No, that's all right. I was merely checking that there wasn't anything else I could attempt to assist with on ultra vires at this point.
As far as I'm concerned.
Before moving on to procedural fairness.
Just remind me, that's ground...
Ground 3.
Ground 3, yeah. This is effectively consultation.
It's consultation, although we would try to avoid the word consultation because, as my Lord Justice Singh pointed out in an important case called Kebble, there is an important distinction between consultation in the sense of enabling general public participation in decision-making on the one hand, and affording someone an opportunity to be heard, something that can arise when particular interests stand to be adversely affected.
Yes.
So here we do submit that this was a case of conspicuous procedural unfairness. The idea that the common law would permit the wiping out of protected interests in this way to the value of millions, hundreds of millions of US dollars, without affording the party whose interests are thus affected any opportunity to be heard is surely extraordinary.
Does the word conspicuous in this context have any legal significance, or is it just rhetoric?
It is mainly the latter,
Yes.
my lord.
But it may have some legal significance. In some,
Depending on the
some
case
it
law,
does.
occasionally it does, but we say actually it doesn't.
Right.
As in, I am not saying we need to show conspicuous unfairness, but in fact it was conspicuous unfairness. But there is a really serious point about this. The common law surely turns its face against property just being taken, extinguished, without any kind of hearing. And it is troubling, to say the least, that in this case the evidence is, from Mr. Chamberlain, that there wasn't even a discussion about needing to afford any kind of fair hearing.
That really is just a rhetorical point, isn't it? Either there's an obligation to afford the opportunity for a hearing, or there isn't. Whether they thought that, whether they discussed whether there should be, doesn't advance the argument, does it?
Possibly not, my lord, but it is.
Might almost go the other way. Shows the urgency of the matter, that it didn't occur to them that would be desirable or practicable. But really, it's a rhetorical point, whichever side
Well, I suppose
deploys it.
I'll certainly come on to the urgency issue,
Yes,
but I
right.
suppose it underlines.
Anyway, but your real point is the very serious consequences of a decision being taken without a hearing, whether they thought about whether to have one or not.
That is certainly our key point, my lord, yes. And here, if we look at paragraph 165 of the Divisional Court's judgment, we have an example of what I, by way of shorthand, called public law light. But they used the phrase wide margin of discretion, or bundle tab, page 138. Accordingly, they said, we reject the claimant's case in relation to procedural fairness and the failure to consult. Consultation wasn't expressly required under the LME rules or the LME Clear rules. It was for the LME and LME Clear to decide whether, whom and how to consult, and they are entitled to a wide margin of discretion. In these circumstances, especially the urgent context, there was no duty to consult the claimants. Well, we do say, in light of the case law such as Osborne and the Parole Board, saying that it is for the court to decide upon matters of procedural fairness, it was wrong for the Divisional Court to say that the LME and LME Clear were entitled to a wide margin of discretion in relation to this issue. I know you're so familiar with Osborne that I won't need to take you to it, but it's paragraph 65 of that case, if you did want to remind yourselves of it. Core Authorities Bundle, page 578.
I think I'm right in thinking, aren't I, that the phrase wide margin of discretion is plucked out of some of the case law on, if I can call it consultation for short, which they'd referred to earlier.
Well, my lord, we say, and I'll show you the key case of Bank Mellett in a moment, that certainly when you're concerned with the kind of procedural fairness requirement that we are concerned with here, as in where someone needs to be, we say, afforded a fair hearing because they have legally protected interests that stand to be severely affected, one is really concerned with the court judging procedural fairness. Of course, taking into account what the decision maker has to say about that, but to say they have a wide margin of discretion, we say in these circumstances, is not right.
Is it worth just looking at, was it Kebble you said?
Yes, I was going to come on to Keble in a moment.
All right,
We can certainly...
don't take it out of...
Yes, I think I was just thinking that a duty itself refers to a discretion whether to consult, though that may be because of the terms of the statute with which
Yes,
they're concerned.
exactly.
Yep.
But it may be that Bank Mellott is the most useful authority for now, and then we'll come on to Keble. So Bank Mellott was referred to at paragraph 154 of the
Sorry,
division.
just before you go there, if we may, so that I can understand what you're saying should have happened. What is the timescale within which you say that consultation ought to have occurred?
So, my lord, we say it could have occurred if that was thought absolutely necessary on the 8th.
Well, you say it was absolutely necessary,
Yes.
so
Yes.
we don't need to worry about that.
No, it could have occurred on the 8th of March. It could have occurred within the 4-hour period that was taken between the announcement of the suspension notice and the announcement of the cancellation notice, or it could have occurred within the time span of the 8th of March, and I'll come on to some of the detail on this in a moment. But we say there was no good reason why that sort of time could not have been taken, even if it involved simply saying in a notice to the market, we are setting up a virtual call. If you have something to say about this, because we're considering cancelling all trades entered into today, please join and speak to us. And we say that's all the more, it is all the more important that that should have been done, given that there was, in fact, as you may have seen, a sort of dialogue with, or certainly a listening to, what those on the other side of the fence had to say, i.e. those members of the exchange who were concerned about the level of margin that might be called from them. So that could all have been done on the 8th of March, we say. I was going to take you to Bank Mellott, but I thought we might take it from the Divisional Court's judgment at paragraph 154, page 136. And perhaps you would like to just remind yourselves of Lord Neuberger's speech, paragraph 179 on that page.
Sorry,
So,
which page of the bundle?
so it's core bundle, core hearing bundle.
Yes, I've got
page
one.
136,
136, yes, thank you.
paragraph 154.
Yeah.
Well, we say the appellants here, or each of the requirements, I should say, for the duty to offer a hearing were satisfied here. The appellants are clearly persons who foreseeably would be significantly detrimentally affected by the decision. Don't think that's disputed. Number two, there's nothing in the regulatory framework, including the LME rulebook, to suggest expressly or impliedly that the duty to give an opportunity to be heard is excluded. And thirdly, for reasons that I'll elaborate on a little bit in a moment, this is not a case where it was impossible or impractical or pointless to afford an opportunity to be heard. And we emphasize Lord Neuberger's reference there to how any argument to the contrary should be very closely examined, because a court, and I quote, will be slow to hold that there is no obligation to give the opportunity.
And what do you say the LME or LME Clear should have done about margin call in the meanwhile? Just hold off on making a decision about whether to make a margin call, and if so, at what level, until the consultation had been concluded, or what?
Yes, well, in fact, as we shall see when we come on to that part of the argument, they actually took a decision to margin that day at the lower price at which trades had been entered into the day before on the 7th of March. So the status quo could have been preserved in that way for the rest of the day, for however long it took, if we assume that it needed to be done within a day. There's also the point which was actually put to the respondents in argument before the divisional court, that, well, people would have known that the LME, market participants would have known that the LME was contemplating a decision of this kind, and they would have no doubt adjusted their trading activity accordingly. They may have held off trading, awaiting the decision. So it's not just a question of saying, well, inevitably trading on, let's say, in other metals would have needed immediate certainty, or it was necessary to have immediate certainty because trading was only suspended on the nickel market, not on other, in relation to other metals. Well, as I say, in our submission, it's a perfectly good point against that to say, well, the market would have accommodated the knowledge that there was a pending decision and would have adjusted their activities accordingly. So although I say there could have been an opportunity to be heard on the 8th, it wouldn't necessarily have had to have been on that day. If another day had been necessary, that could have been allowed. There was, in the court below, some slight dispute, I think, as to whether Lord Neuberger's observation in paragraph 179 should govern the situation, or whether one should focus on what Lord Sumption had to say at paragraph 31, where he said that whether there's a duty to consult depends on the particular circumstances.
There's no real...
Absolutely, there's no real...
I mean, Lord Sumption perhaps emphasises slightly more the kinds of circumstances which would need to be shown.
Yes. That then, I think, brings us to the Keble case and the important distinction between general consultation and affording an opportunity to be heard. You have that at Core Authorities Bundle, tab 20, which I think is your volume 2, page 1339.
Core Authorities Bundle.
Tab 20.
I think it's 3.
It's in Bundle 3.
Oh, I'm so sorry. It is Bundle 3, my fault.
I see that my lord, the Vice President, was also in that case.
I had forgotten all about it.
I had forgotten that I'd ever given this judgment.
Well,
Whereas, yes, I see mine was an important contribution to the jurisprudence. Yes.
it's a happy, well, it's not a coincidence, I'm sure that we need to go to it. The particular paragraph then is paragraph 68 to 69 on page 1358. And it's probably right to start actually at paragraph 69. If I could just invite your lordships to read through those paragraphs.
So which paragraph? 69?
67 to 69,
yes,
and including 69.
Yep, thank you. Having read it, reread it, I still agree with it. Pellucid.
Yes. So we gratefully fasten on that important distinction, and we, of course, say we fall into perhaps it's the second category out of the two here,
Yeah.
which
No,
is
I see exactly why you put me up, and that what said there is obviously right, but as my lord does say in that passage, consultation is sometimes a useful shorthand.
yes.
So
Yes.
if I'm using it, I'm only using it in that sense.
Indeed, as am I, if I were to use it in that sense. Yes, thank you. So, with that important distinction in mind, and also having in mind the criteria, as it were, set out by Lord Newburger in Bank Mellott, and the need to examine very closely whether it's impossible, impractical, or pointless to offer an opportunity to be heard. We then go to the facts here. I already mentioned that it's an important part of the facts that there was a kind of, to use that shorthand, consultation with those who were concerned about the margin they might be called upon to pay. No time to go through the details of that, and indeed it's not necessary, but you have references to it in Chamberlain 1, the following paragraphs, if I may, for your reference. Paragraph 147, 154, 164.
Sorry, paragraph 147.
147,
Yeah.
154,
Yeah.
164, 165, and 175.
Yeah. And just remind me where in the bundles is that?
So that's core supplementary bundle,
Yeah.
tab 3, page 95.
Thank you very much.
So you have to factor in that that particular, I'll call it dialogue, with other market participants was happening that morning, which particularly starkly then raises the question, could that not have happened also in relation to those like the appellants, as it were, on the other side of the fence? Now,
Were these conversations with people who were telephoning Mr. Chamberlain, were they people who were actually on the other side of transactions entered into after midnight on the 7th, 8th of March? Or were they people who were not necessarily parties to trades agreed after midnight, but who were concerned that if margin was called at the level which took account of such trades as had been entered into, they would be unable to pay?
I suspect both of those, my lord. I suspect both. I can't now tell you exactly who they were, but I suspect both.
I mean, the latter category is, well, let me ask you, is that relevant information for Mr. Chamberlain to have? Because one of the things that was concerning him was that if the action which he took was not taken, then there could be multiple bankruptcies.
Well, one of the submissions we make is that the power to cancel trades simply wasn't there in order to assist in the setting of margin at any particular level. So in that sense, it wasn't relevant. But of course, I can see that LME Clear will have wanted to have a picture, maybe, as to how things stood with those who would be liable to pay margin at whatever level. But our point is really, if you're going to do that, if you're going to look into that, and you're actually going to communicate with those individuals, then it underlines the need, as a matter of procedural fairness, to speak to those on what I've called the other side of the fence, my clients, to make an effort to accommodate that. Now, the divisional court said at paragraph 131 of the judgment that if time had been taken, and I'm paraphrasing now, to afford an opportunity to be heard, then the decision would have been postponed, and I quote, until sometime after the 8th of March. So that was their view. But I've already made the point that actually it would not necessarily have had to be after the 8th of March. There could have been, to use the shorthand, consultation on that day. The immediate concern over trading in the nickel market had been dealt with through the suspension, and you have our point that so far as trading in relation to other metals is concerned, market participants would have been liable to adjust their behavior pending this decision coming out. And again, as I said, there were 4 hours just between the suspension decision being announced and the cancellation decision that could have been used, we say, even to set up a virtual call, as I mentioned. And there was no risk of under-collateralization because that had already been dealt with. This is the answer I gave to my Lord's point earlier. That had been dealt with by LME Clear taking the view, well, both respondents deciding that margin could be called at the lower price of the previous day. I'll say more about that.
Why should they adjust their trading in other metals when, for all anybody knows, they might have a need to trade in those other metals? They might have physical positions they needed to hedge. They might have long or short positions they needed to cover. To simply say we're not going into whatever the other metal markets are because of the problem on the nickel trade would seem to me to introduce further disturbance and distortion in the market, or at least the risk of that.
Well, my Lord, it would have been no doubt a matter for them to weigh up whether it would be in their interests pending a decision from the LME or on the question of cancellation. It would have been for them to weigh up whether it would have been in their interests to await the outcome of that decision, or nevertheless, depending on their prediction as to what the decision might be, whether it would be in their interest to carry on trading. That would have been a matter for them. But our point is that it is not inevitable that trading would simply have carried on and then been suddenly affected, or members would have been suddenly affected in a certain way by the cancellation decision.
And in the meanwhile, if either no margin call was made for nickel, or it was limited to the previous day's close at a time when it was still possible that the post-midnight trades might stand, the LME would have been under-collateralized, wouldn't it?
Well, no, my Lord, this raises head-on one of the points I'll come on to in due course. It wouldn't, because if the LME LME Clear takes the view that the market price is at a certain level, as it must have done because it did decide to margin for the present time at a certain level, i.e. the closing price on the 7th of March, if it takes the view that that is an appropriate price, a proxy for the market price at which to margin, then it will not be under-collateralized. That is how the system works.
Well, it will if the post-midnight trades stand, because if they stand, then they represent the market price.
Well, no, my lord, there's evidence from Mr. Chamberlain and Mr. Farnham to the effect that they did not represent the market price. It was acknowledged, at least in theory, by them that it would be possible to margin at a different price, which was thought to be the market price, and that's what was in fact done. But that does not hinge on whether trades stand or do not stand. The market price is not necessarily that of the last actual trades entered into. That is fundamental to one of our rationality points. And that is why you have a specific LME Clear rule that allows LME Clear to amend the price at which it margins so as to reflect what it believes is the true market price, even though there have been trades entered into at a different price. But I will need to come back to that. In terms of that dialogue, as I have called it, with others, those who were liable to pay margin, it is right to note also that certainly one of them made a specific representation to Mr. Chamberlain as to what ought to be done, i.e., said in no uncertain terms, the trades should be cancelled. That's Chamberlain 1, paragraph 164, page...
Which paragraph did you say?
Paragraph 164, page 99 of Core Supplementary Bundle, tab 3. So it was not just representations about precarious financial position if margin were to be called at whatever level, but also, as I say, specific representation about what ought to be done, which, of course, the appellants didn't have an opportunity to do. It has been said on behalf of the respondents that, well, they weren't, or Mr. Chamberlain wasn't influenced by any such views, but in fact, his evidence does say that some of what he was told, at any rate, substantiated his concerns. See paragraphs 147 and 148 of his first witness statement. Then I should perhaps pick up that Mr. Chamberlain himself says, well, if the appellants had endeavoured to contact me, I would have endeavoured to speak to them. That's what he says in his second witness statement at paragraph 10. Well, we say that then rather tends to underline that it appears it would have been possible to speak to the appellants. All the more reason for the respondents then to proactively invite some speaking with the appellants.
So what was the page reference for that second statement?
That was Core Supplementary Bundle, tab 6, page 221.
Thank you.
I'll just say at this stage how impressed I am by how well referenced your notes are. You haven't missed a reference so far.
Thank you very much. That's very flattering. Then the respondents, I think, make the point, well, there might have been difficulties identifying and contacting the affected class, i.e. the appellants. class? Well, through the simple mechanism of putting out a notice, which we know the whole market immediately found out about, that wouldn't have caused a problem. The notice could just have said, please get in touch, we're setting up a call, or even just please get in touch if you want to say something about the possibility of your trades being cancelled. But in any event, of course, it would have been possible for the LME and LME Clear to contact the relevant members, and if there was any concern about conflicts between members or conflicts between members and clients, then of course one could have asked for details of clients who had traded that day through members, and no doubt clients such as the appellants would have readily given their consent to their details then being made available so that they could have been consulted, to use that word in shorthand. Well, those points, my lords, have not, so far as we can make out, been met by either the divisional court or the respondents.
They were points all of which were made, you say?
Yes. And just in terms of one point that they make, which is, well, we would have needed to consult with every market participant holding an open position, and that would have been tricky. Well, of course, you have our point. There was a sense in which they were in consultation with such persons, but also there is a real significant difference between persons such as the appellants, whose trades actually stood to be wiped out, and those persons who were liable to pay additional margin, perhaps, but margin, of course, after all, being something that works as a collateral, but say, if you then were to leave the market, it is returned to you. So it's a qualitatively different thing, quite apart from anything else. Then I think the point is made, well, weren't you told, you the appellants, that a decision was going to be made about possibly cancelling the trades, and couldn't you, shouldn't you have got in touch? Well, no, the answer is that what fairness requires is an actual invitation to make representations, something to make it clear that the decision maker is willing to listen. I won't ask you to turn it up, but there's a case called British Blind and Shutters Association, and the reference is Supplementary Authorities Bundle, Volume 4, tab 39, at page 1580, where the administrative court endorsed the idea for, in this case, actually general consultation, that there had to be, and I quote, a genuine invitation to offer views. That's for your note, paragraphs 52 to 53. There was no such thing in the relevant suspension notice. And then there's the question of, would representations have made any difference, which is posed by Mr. Chamberlain's evidence.
Well, I see the time.
Yes.
And that would be a sensible thing to deal with after the adjournment. You feel you're up with your time, Mr. Charles-Frisk? We've been fairly moderate in our interventions.
I wish I could say yes, my lord, but I fear not. I will skate as fast as I can, but I don't know if there's any possibility.
Well, I think skating fast is often not the best way, because then we can't take it in. I think it's selection of what are the points you really need to make, because and then make those properly rather than rush through them all. But you're very experienced. I don't need to tell you all this, but that will help us best.
Is there, taking all of that on board, my lord, is there any chance of the court potentially sitting until 4:30 today, if necessary?
We will give that some thought. My immediate reaction is, because of my own commitments, no. But we will give some thought about timing generally. But don't take that as a hint that you will definitely get some. Very well. Can I just mention one other thing? Whatever needs to be done to the laptop here in order to show the running transcript hasn't been done. I haven't frankly felt the need, but a moment might arise where we all want to look at the transcript of something said, and then it would be useful to be able to access it. So could whoever knows about this just have a look at it over the adjournment. 2 o'clock.
Court rise, if able.